Hi, my name is Angel, and welcome to IHR Consulting FAQ. Our topic for today is contract of service. First question, what is the responsibility of the employer, or business that is newly established? The answer is, a new employer is required to notify the Labor Department, within 90 days of formation, registration or commencement of business, in accordance to Section 63A of the Employment Act 1955. In this case, the employer shall furnish the following information in writing, to the nearest labor office addressed to the Director of Labor. 1. Registered company name, address and nature of business. 2. Name of person in charge of business. 3. Information outlining the categories and total number of employees employed. Second question, what happens if the employer fails to follow to Section 63A? The answer is, in the event, if the employer fails to do so or provides false information, the employer would be guilty of an offense and is liable for conviction and could be served a fine. Third question, what are the other responsibilities of the employer? The answers are, A. Every employer should maintain a register of all employees containing detailed information of the employee, that is, personal details, details of terms and conditions of employment, details of wages and allowance due to employees. B. The employer should maintain a personal file of each employee with their letter of offer, payroll information and any other information pertaining to the employment. Fourth question, who are covered under the Employment Act 1955? The right answer would be, the Act covers those employees under the following categories. A. Those irrespective of occupation, whose earning a monthly wage of 1,500 ringgit or below. B. Those earning more than 1,500 ringgit but engaged in manual labor work including an artisan or apprentice and the normal labor work exceeds one-half of their total work time. C. Those engaged in operations or maintenance of mechanically propelled vehicle for transport of passenger or goods for commercial purposes. D. Those who are supervising or overseeing other employees, engaged in manual labor employed by the same employer. E. Those who are engaged as a domestic servant. F. Those who are engaged in any capacity in vessel registered in Malaysia and is not an officer certified under the Merchant Shipping Acts of the United Kingdom. Fifth question, what is the definition of wages under the Employment Act 1955? Answer. Wages is simply defined as base salary and all other payments, that is allowances, commissions and overtime. However, wages does not include A. Value of benefits like housing, food or meal, utility expenses or medical benefits, contribution paid by employer to pension fund, provident fund, retrenchment, layoff or retirement benefits. C. Traveling allowances and bonuses. Sixth question, what is a contract? A contract is an agreement by two parties to appoint and serve based on an agreed terms of appointment. Question 7, how many types of contract are there? There are two types of contract. A. Contract for service, an engagement or agreement between two parties, example, a principal and a service provider. This is, by the way, not an employment contract. B. Contract of service, an agreement between two parties whether orally or in writing, whereby one person agrees to employ another as an employee, and the other agrees to serve as an employee. C. There are several types of contract of service. A. Full-time contract, where the employee is engaged on a full-time basis without any specific duration. B. Contractual contract, where the employee is engaged on a full-time basis but subject to a duration such as 1 year, 2 years and so forth. D. Apprenticeship contract, where a person is engaged to be trained systematically for a trade for a specified period which is not less than 2 years. Question 8. What is the definition of part-time workers? Well, in accordance to Part-Time Work Regulations 2010, a part-time employee is defined as those who work between 30% and 70% of the normal working hours of a full-time employee. Under this new regulation, part-time workers would now be eligible to enjoy certain incentives including public holidays, annual leave, medical leaves, overtime, statutory contributions and other incentives on prorated basis. Question 9. What should be written in employment contract or contract of service? For your information, in any contract of service, the information, terms and conditions must be specified prior to the commencement of employment. 1. Name of employee and identity number. 2. Position. 3. Wages details, base salary, allowances and incentives. 4. Probationary period. 5. Working hours. 6. Other benefits, annual leave, medical leave, public holidays and medical coverage. 7. Termination clause. 8. Retirement age. 9. Statutory deductions or contributions. 10. Office regulations, code of conduct, ethics and others. 10th question. What happens if the employment terms and conditions stated in the contract is less favorable than the Employment Act 1955? The answer to this question is, if any terms of employment stated in the contract of service is less favorable than the Employment Act, then the terms of employment under the Employment Act shall prevail. As terms and conditions under the employment law is that the minimum guideline must be adhered or complied to. Last question. Can the employer restrain an employee from joining a union through the contract of service? The answer is, any employer cannot restrain an employee in any manner whatsoever from joining a registered trade union, participating in union activities or associating with any person for the purpose of organizing a union.